Peace of Mind with Ken Pope. As a parent of a child with a disability or special needs, you need to navigate the complex legal issues of providing continued care and quality of life for your child. You need peace of mind with Ken Pope.
This is a Peace of Mind radio show, and welcome everyone who's listening. My name's Ken Pope, and the purpose of the show every last Monday of every month is to talk about families who have children with special needs and disabilities and issues that touch on those families. Families are 1 in 10 in the province of Ontario. It's an amazing number. And we deal with all sorts of issues between childhood issues, IEPs at school, testing, most often dealing with provincial benefits when the kids turn 18, issues with ODSP, Henson trusts and wills for the parents to provide for the children when the parents are gone. You know, the core issue here is what will happen to my child when I'm gone. So my law practice assists them with that sort of thing, and about 13 other things that deal with them. And one of those topics is powers of attorney from the child when they're adults, so that parents can help manage their affairs. And if the child is not competent, legal guardianship applications to provide them the legal ability to manage the child's affairs, and often to have a younger person along with them as guardian, such as a sibling, so that when the parents are gone, that guardian, that child, that brother and sister, can then assist with various things. This is especially important as the parents get older and this kind of transition becomes imminent, because what you have is situations where people, for example, spoke with a client yesterday. He has a daughter, she's 31, and she happens to have Down syndrome. She's an only child, and during their lifetime, the parents, he and his wife, have been able to get cooperation from doctors, and they of course they can be the account holder for her registered disability savings plan. You know, they don't need power of attorney for that, but when they're gone, they're the only ones who, by statute, could, except if that girl happened to have a husband, which she doesn't. So somebody has to have a power of attorney to manage her RDSP, which would be several $100,000 by the time she's 60. And when it starts to issue money, it'll pay out directly to her at age 60 for 23 years. And similarly, the mother here is a teacher. She's going to retire in about 5 years. And this child, this 31-year-old child, potentially stands one day to receive an adult dependent survivor pension from her mother, the teacher. And it would be eventually 50% of the mother's original pension. So if her pension was $60,000, which is not uncommon, the girl would get $30,000. But of course, you have to be competent to apply for it and to manage it. So, you know, these are serious issues. And for every one of these children, when they turn 65, someone will have to apply for old age security and guaranteed income supplements for them, because they'll transition off of ODSP. They'll get slightly more money as a result. They'll get about $18,000 compared to about $14,000 on ODSP. But someone has to apply for it and then manage it once it's being paid. So you can see that there's this transitional issue, which often requires legal guardianship. And it manifests itself in many cases. The difference between a power of attorney and a legal guardianship is that the power of attorney is granted by someone who's competent, so that others could assist them if they needed assistance. And it can, of course, be revoked. And in lots of cases, you'll find that, for example, with the girl with Down syndrome, the parents have put powers of attorney in place. But the real question is, truly, as long as doctors and banks and so on are prepared to hang their hat on the power of attorney, I'm fine. But what happens then is that when the parents are gone, whoever is the follow-up person, such as a sibling of the girl, they don't get the same cooperation from the medical authorities and the banks and Canada Revenue, for tax filing and that sort of thing. So becomes an issue at that point. A legal guardianship is by way of a legal application to the court. It's in all of the ones we do, we handle these applications all over the province. They're all filed in Ottawa, but they're effective, wherever the family is. There's no need to appear. There's no court appearances. And then the court issues this certificate appointing the legal guardians, and they then, by way of this order, stand in the shoes of the person who has been found to be not competent. Now, as part of this process, you have to have 2 capacity assessments, even in cases where it's abundantly clear that the child is not competent. And at that point, what we do, of course, is we engage capacity assessors around the province to do these assessments. You have to have 2 assessments. So today I've invited Dan Silver as our special guest. Dan's a social worker and also an approved capacity assessor. And Dan is going to discuss the process for these assessments. They're all standardized processes, but of course there's variations in each file. And Dan's going to talk about the process for this and the kinds of questions that are asked and the difference between understanding and appreciating the implications of actions. Dan, welcome to the show. I'm glad to have you here. I've always been impressed with your work.
Well, thank you very much. It's enjoyable work because we see the people that are helped by it. Yeah. So let me tell you a little bit about the process. In advance of an assessment, when I receive a call, whether it's from Ken's office or it's from somebody in the public, I need to first find out what is the reason for the assessment, because different types of paperwork are done, and as Ken had mentioned a moment ago, they're pretty standardized with some variations on what is the reason. So I need to know if it's to have a guardian appointed to manage finances or healthcare or both, and whether it's going to be statutory through the Public Guardian and Trustee's Office or through the courts for guardianship, or if it's to activate an existing power of attorney. Another possibility is that it is to change a will, and then the assessments for testamentary capacity to protect against the future challenge to an estate by people who were formerly in the will but will no longer be in the will. Or maybe it's coming from a lawyer who wants to be sure that their client is capable of instructing counsel, and the lawyer wants to be sure that the individual understands the information that's being shared with them and is able to process it properly. So let's talk about guardianships. Some of the questions that, again, more questions that I need to ask up front are if it has to do with inability to manage the property, meaning the finances, the money coming in and the things that need to get paid going out, or if it has to do with exploitation. I also need to gather information about the person's inability to manage their personal care, and I'll talk about that in just a moment. And sometimes it's to terminate, to end an existing guardianship. Also, I need to know if the person's life is being endangered and if their safety is at risk. And sometimes it's simply to activate a power of attorney. So once those questions are answered, then I'm able to proceed. One more very important one is that all assessments must be voluntary in these cases. rights advice is provided up front and a person is informed, voluntary, that they can stop it at any time, and that if they have questions, that they need to stop me and they need to ask me what issues they need to be able to get clarification on what's going on. So some useful information that I need in advance, so that when I'm asking questions of a person who's being assessed, so that I know that I'm getting accurate information when it comes to the income. They may get some kind of benefit several times a year. I want to know what their expenses are: electricity, taxes, food, whether they have big expenses, or whether maybe they just spend a little bit of money on a chocolate bar or a bag of cookies, whether they pay auto insurance, if they take the bus, how much they pay for the bus, if they take a taxi, and other things, rent and food. Those are examples of questions that I ask, and if I know the answers in advance, then I know whether I'm getting accurate answers. And the reason that this is important is because I need to know that they understand the information. The definition of understanding the information would be their ability. Understand refers to the ability to understand the information that's relevant to making decisions. If the person understands the information, then they may be capable. But there's a second part to the test. And the second part of the test is, do they appreciate the consequences of mismanagement? So the definition is, appreciate refers to the ability, reasonably foreseeable consequences of a decision or lack of a decision, and failure to understand or appreciate is grounds to conclude incapacity. Understanding, appreciate the consequences of mismanagement, then the opinion will be incapable. And in the case of guardianship, that's what's presented to the courts, and so that the paperwork issued by the court will support incapacity, and then the guardian can take care of them. When it comes to the personal care, and that's the health care decisions, the things that we're looking to know and to describe in the report speaks to 6 domains of healthcare, and they are the person's ability to manage their own healthcare, meaning medicines, medical checkups, follow through. The next is nutrition. Not only are they able to provide themselves with the necessary nutrition to be healthy, but are they able to prepare it for themselves? The next is shelter. Can they provide their own shelter? Can they do maintenance repairs? Do they even know if maintenance repairs are necessary? For example, if the roof is leaking, do they know to call a contractor? Or do they know to tell somebody in a position of authority so that that person can actually come through and can take care of it for them? The next domain is clothing. Do they know that in the wintertime they need to put on winter boots and a coat and maybe a scarf and a hat and gloves, or will they just walk outside in a pair of shorts? The next domain is hygiene. Are they able to take care of their hygiene? And hygiene is a lot more complex than just taking a shower, as you can imagine. The last one is safety. Are they able to keep themselves safe? Do they know to lock the doors? If they don't know to lock the doors and somebody just walks into the house, not like home invasions are a regular thing, or they don't happen often, but if they can't keep themselves safe in the house, if they can't shovel the sidewalk, if that's something that they would have to do, if they're walking down the street and they see a dog and it's a growling and aggressive dog, do they know to sidestep it? Do they know to turn around and walk the other direction? I'll also want to be able to collect relevant medical information, documentation, and reports so that I can review them, because those reports may support capacity, or they may also support incapacity. And so weighing that information and presenting it, and then coming up with an opinion based on the other information. Sometimes I'll need a consent to share personal health information. Sometimes the information will just be provided to me. Ken, any...
Yeah, the most common concern that my clients, my parents have, is that their child could be manipulated or misled or brought into signing contracts for credit cards or cell phones, which would then be stolen from them. And that's the main concern. The children of my clients' families, normally when we're applying for guardianship, it's clear that excuse me, that the child is not competent. And the issue really is if they can't sign a power of attorney to have someone help them when their parents are gone, what will happen to them? What will happen to my child when I'm gone? So that's the biggest issue for my clients. In today's world, Dan, do you have to go and physically see these people, or could you do a remote assessment?
That's an excellent question, especially given the state of emergency and pandemic that's going on right now. The preference always is to see the person face to face. I do quite a few video conferences. As a psychotherapist, I meet with people regularly. But if I'm doing an assessment and it's a one-time assessment, there's some things that I really need to be sure of in advance. And so there is some difficulty in doing online assessments, but those difficulties can be overcome. So by way of example, I need to know that there's no undue influence in the room at the time. So when I meet with a person, I prefer to meet with them, just them, with nobody else there. In the case of individuals who have significant disabilities, oftentimes there will be somebody else in the room to keep them comfortable. And having said that, if the camera, which is on the person, is only on that person, or if it's on that person with the significant others sitting behind them, so as undue influence, I know that no undue influence is being applied, that can work.
Yeah, I can see that that's clearly an issue, especially in, the excuse me, the dueling powers of attorney situation where there's two or more siblings and they're struggling to manage the affairs of the mother, and of course they're both concerned that the other one is trying to manipulate them or control them, or perhaps have undue influence.
Right.
It's a very interesting situation.
Yeah, in the case of an individual with a significant disability who's, let's say, still living with their parents and they just turned 18 years old, and the parents are seeking guardianship. In a case like that, if I'm able to do a good review of the medical information and the financial information in advance of the call, and I'm able to formulate an opinion based on that, and there's no indication that it's other than a straight guardianship application, then what I need to do is we as capacity assessors need to take into consideration what our college says.
Yeah, I understand. One of the factors in my practice is the legal guardians have to be joint. They can't be the parents first, and then when the parents are gone, this named brother or sister, they have to be joint. And this is, in practice, this isn't an issue. It's just that it's not what the client expected. So, for example, you could have the three of them, mom, dad, and a brother, or an uncle even, for example, and one of the cousins, the child of the uncle. And in practice, the uncle and his son don't really want to be currently involved. So you can do a specialized form of power of attorney from them, granting their guardianship authority to allow it to be exercised by the mother and father separately, together with that power of attorney. And of course, you're trying to have someone who will be a legal guardian alive after the parents are gone, and if at all possible, of a similar age to the child. And that's not always possible right away. So what you would do is you'd start out with the parents and perhaps one of their brothers or sisters, and then 10 or 12 years, 10 or 15 years later, you might add one of the cousins, or maybe two of the cousins. If you're fortunate enough to have nieces and nephews, cousins of your child, because of course a lot of times, we have so many singleton children. This situation I was describing where the girl who's 31 with Down syndrome, she's an only child. So what do you do here? How do you tell? And in this case, for example, the father has a slightly older sister, and she has some children, but of course they're only slightly older than his girl. So what you have to do is you have to plan to add on later when it becomes appropriate. And this is the same with the trustees of the trust. There's often a similarity between the trustees of the Henson Trust for the child and the guardianship. Wouldn't be uncommon, would it? And of course, in lots of cases, you can't think of who that alternate trustee is who's of a similar age to your child, the beneficiary of the Henson Trust. And so what we do in that case is we give the last surviving trustee, the uncle, let's say, the power to replace himself, either while alive or in his will, which is not complicated. It's just that that's not how it works with legal guardianship. So it's an ongoing issue, of course. But that's the nature of life. You have to deal with these ongoing issues and simply make the best decision you can. And in my experience, the clients ask me, well, when should we do this? And because there are legal fees and assessment fees, court fees involved, we don't try to sell this service. It's only something that you do if the client needs it, and it's the best choice for them. And sometimes, people will say, well, I'll wait until the first of us has passed on. And then in other cases, the parents are just right on top of everything, as they have been ever since the day the child was born. And they say, well, this isn't something I want to leave for my other children to deal with. We're going to do this right now, so let's get going. So it's a very interesting process. We're coming to the end of the show. We're very close. Dan, did you have any final comments that you'd like to make?
I do. And parents' greatest fear in my 25 years as a social worker, working with families with loved ones with disabilities, is who's going to take care of my child when I'm no longer able to do it. And my instinct tells me, get it done sooner rather than later, and make sure that the people who are named to provide that care really understand the person that is going to be cared for, and that they have great compassion for the person's integrity and their ability to participate in the decision making, if that's possible.
Yes, there's an ideological argument that you should never do guardianships. You should just have assisted decision making, and there's a role for that, certainly.
Yes,
but legal guardianship does not in any way stop the guardians from consulting with the person, helping them to make decisions. There's no restriction at all on that. Although legally speaking, they don't have the contractual legal authority to do these things. That's true. But there's no reason at all that the legal guardians can't consult and discuss with the child, and of course the parents do. It's just a fact. The ideological idea that somehow the parents, the legal guardians of the child, are going to somehow abuse them or manipulate them or not do what's in their best interest. It's just not a starter as far as my families are concerned. Maybe in some other fact situation.
Right. So there's an awful lot to be learned about the process and where families can go, and if I might just suggest, any of the listeners out there might want to tune in to some of the podcasts that are offered, and I know that you offer one, Ken.
That's true, and we've recently done a webcast. There were 440 registrants. So if anybody listening wants to have us forward that recorded webcast and the PowerPoint slides, we'll be happy to do that. Just you can contact my office, contact Karen at kpopelaw.ca, Karen at kpopelaw.ca, or just go to the website and contact us that way. Dan, if people wanted assistance from you, how would they? What's the simplest way to contact you?
Well, people can write to me at dan@dansilver.ca, just my name, or they can call me at 905-641-2111. That's my phone number.
That's great. Well, you should go back to self-isolation, Dan. And I'm going to go back to my office. We've got the 7-story building all to ourselves, myself and my 6 lawyers and paralegals, and so we're self-isolating in our office because everybody else has gone home.
I hear you. I work in a big medical building, and there's nobody there, so I've been working from my home, and it's pleasurable. But I hope everybody stays safe out there.
That's right.
And we get through this, and we're prepared. We're prepared if it ever happens again.
That's it. Okay. Thank you, everyone, for listening. And the show is at 9:00 on the last Monday of every morning of every month.